most of the arguments, I mean the best arguments are still whether I'm in Hong Kong or Vienna, because then you live with the problem, right? Every day, just watch around, then got to go give feedback, talk to them, then go watch another round, then I judge around. So this whole life problem becomes part of life. And that's when you really start thinking of good arguments. Okay, so I guess what we can do is you just go through the round, right? And then after that we can talk. Okay.
Hey, you're actually missing about the
Oh,
Problem.
I'm sorry. That's the memo. I'm so sorry.
the man.
Okay, so I mean whenever you're ready.
Has it
Yeah.
been recording? Okay. Members of the tribunal, parties have agreed for the order of proceedings that we will be addressing issues A and C stated in procedural order number 1 first, followed by a round of rebuttal and sur-rebuttal. And then the second counsel for both the claimant and the respondent will be addressing issue B as stated in procedural order number 1, followed again by another round of rebuttal and sur-rebuttal. Good evening, members of the tribunal. My name is Wong Yan Yi, and together with my co-counsel, Mr. Won Chien Lim, we appear on behalf of the claimant, Kaihari Waina Limited. Across from us are counsel for the respondents, Mr. Sim and Ms. Nee. I will be addressing this tribunal for the next 15 minutes, and I reserve a further 1 minute for my rebuttal. Members of the tribunal, I'll be addressing issues A and C, which are the disclosure of documents and the disgorgement of profits that the claimants seek. The wine industry, which is the industry between where the parties operate, is based on mutual trust and long-lasting relationships. The parties have entered into this contract to cement this relationship. However, with the increasing value of Diamond Mata Weldin, the respondents sought to earn a greater profit by defaulting on its obligations owed to the claimants and contracted with Superwines instead. It is against this backdrop that the claimants have 2 submissions to make. First, that the claimant should be entitled to the respondent's profits from Superwines, and second, that this tribunal should order the disclosure of relevant documents. Turning to my first submission, the claim for damages that the claimants seek stems from the respondent's breach in its fierce refusal to deliver the wine that the claimant had ordered, and this is presumed to be a breach in procedural order number 1. For ease of reference, the claimant's request in this case is for the breaching party's profits, which will be referred to as a gains-based measure of damages.
So it seems to me that you want to address substance before the procedure. Is there any reason why we're not dealing with the evidential issues first? I mean, I would presume that in a normal proceeding, you deal with evidence before dealing with. You need to know what we can consider before we even go to the substance.
Understood, Mr. President. However, in this case, because the issue of document disclosure is contingent on this tribunal finding that a disgorgement of profits is a relevant measure of damages for the parties, and only if this tribunal finds that a disgorgement of profits is relevant will the documents sought in the claimant's request for disclosure be relevant for consideration. Therefore, the preliminary issue on whether a disgorgement of profits in the first place is an appropriate remedy should first be considered by this tribunal.
Has it been framed in this arbitration as a preliminary issue?
In this case, it has been framed according to procedural order number 1 to be a preliminary issue where this.
Where's that?
My apologies. Procedural order number 1 is found at page 50 of the record.
50.
Yes. And if I may turn this tribunal, my apologies, to page 51 for the later half of the order. It stated that can the claimant claim the profits the respondent made by selling the bottles to Superwine as part of his damages?
Yeah, but that's what I'm asking. I'm just saying it's not framed as we have to deal with that first, right? I mean, it's not something, so let's deal with this. I meant as a preliminary issue before moving on to the other issues. I mean, it's just framed as one of the issues in this case.
If this tribunal would like, I could address this tribunal.
Yeah, maybe just the first question I have is, so your case is if we disagree on the disgorgement, then you agree that there's no power to order documents.
Yes.
No power, or I should not?
Should not. In any event, should not.
So I have the power. I mean, that's why I think that there seems to be a few layers to this. Is it uncontentious that we have the power to order documents?
It is contended by the respondents that this tribunal does not have the power. But if this tribunal holds that a disgorgement of profit is not available for the claimant in any event, And this issue of document disclosure will no longer be relevant.
We would still have the power, but we should not. That's
Yes.
your position. Okay. Let's just deal with evidence on the basis that first, I mean, this seems neater to me, and on the basis that we agree with you that this is a measure that can be ordered in this case.
So, Mr. President, so I'll go on to address the
Yes.
issue of against-based measure of damages. So the
So
claimant,
I mean, let's deal with the evidence
okay,
on
sure.
the assumption that
It's relevant.
this is relevant. Yes. I mean that we can order this damage that you see.
Certainly, Mr. President. On the issue of document disclosure, the claimant in this case is stating that this tribunal has the power and should order document disclosure. In this case, the claimant recognizes that the key problem that we seek is Article 20 of the Framework Agreement found at page 9 of the record, and if this tribunal can turn with me.
Okay. Yes.
So Article 20 here states that the parties, my apologies, at Article 20, if I may point to the second last line of Article 20, it states parties agree that no discovery shall be allowed. And this is the key hurdle that the claimant must circumvent in order to state that this tribunal has the power. While it is recognized that the
Circumvent. So you accept that this is an agreement and you are trying to circumvent it.
my apologies, Mr. President, rather that the claimants are stating that this term should not preclude this tribunal from ordering disclosure. And Article 8 of the CRSG states in interpreting a term of the contract, party intention should be key. And in this case, if I may point this tribunal to page 31 of the record, this is Mr. Weinbauer's witness statement. At the last paragraph, if I may quote to this tribunal, I understood the clause to exclude all types of requests for documents which go beyond requests for particular documents in very specific circumstances.
Counsel, first, when I interpret a clause like this, do I look at objective or subjective intention?
Mr. President, based on Article 8 of the CISG, it would be the intention of the drafter of the clause, so long as the other party ought to have known this intention.
So the subjective intention of the drafter.
Yes, and Mr. President, in this case, this clause was incorporated by the claimants.
Okay.
And in this case, we point to the respondent's witness statement on the understanding of this clause because the respondent's key contention is that they understood this clause to mean no document disclosure at all should be
Okay.
permissible.
Counsel, before I go there, I mean, you go there, is that only applicable if there's an ambiguity in the clause? If the clause is crystal clear in the words, do we still have to go into intention? Is that what the CISG prescribes, or can we just say, I mean, not talk about this clause, but if the clause is crystal clear, I mean, so obvious in the language.
Mr. President, if the clause was clear and there was no question that there could be a different interpretation, then the objective meaning of the words chosen by the party should weigh very heavily on the minds of the tribunal. However, because of party autonomy being key to determining this tribunal's powers for disclosure, it is relevant to consider the intention of the parties. And in this case, the respondents clearly read the statement to include some form of disclosure and not eliminating all forms of disclosure.
So, Mr. Werner Weinbauer is the opposing parties or your clients?
Mr. President, Mr. Weinbauer is the CEO for the respondent who was chiefly involved in the negotiation between the parties.
And they drafted this.
My apologies, the claimants drafted the clause.
You drafted it, so if you are the claimant, right?
Yes.
And you drafted the clause. So
Yes.
what is why are you telling me their intention? Shouldn't I hear what is your intention? Because you're telling me we look at drafter's intention first, right?
My apologies. Then if I may point this tribunal to page 20 of the record, this is the witness statement from one of the legal counsel for the claimants. And in this...
Page, sorry, what's
Page 20.
20, yeah, okay.
Yeah. So in this case, Mrs. Kim Lee stated that when we incorporated this term into the contract, the key intention is to exclude wide US-style discovery.
Where is that? I don't see it.
This is at paragraph 3.
Okay.
And in this case, let me see the line. The 6th line, and if I may quote, the brothers' company had been involved in a multi-million court case with extensive pre-trial discovery in the US courts. As a consequence, they had inserted this arbitration clause into their contracts, excluding discovery of documents.
Okay, yeah.
And the next paragraph, if I may take this tribunal through, it says, He explained that we had taken over the clause and also tried to produce as little paper as possible. And sorry, my apologies. In the next paragraph, again, it states, to solidify the understanding of the claimant, my understanding of the clause was that it meant to exclude only very broad US-style discovery. And it is because of this line that we say the claimant's intention in including Article 20 was merely to exclude wide US-style discovery.
Fair enough, but why didn't you just use the word then? I mean, you could have said no US-style discovery. Shall be allowed. Why do you use no discovery? I mean, is this just something that you have reasoned out ex post?
Mr. President, it is true that perhaps the claimants could have been clearer. However, considering at the time of contracting, they wouldn't be cognizant of all the possibilities of dispute. They had drafted the term in a slightly broader matter to only refer more generically to discovery.
And no lawyers were involved in this drafting.
Yes, there were lawyers involved.
I would assume a lawyer would know what they're doing, right? I mean, they put the word discovery. I mean, lawyers don't know the difference between common law discovery or the US-style discovery and arbitration discovery or discovery in civil law, which is generally not permitted. I mean, surely a lawyer would know that, right?
Yes, Mr. President, and perhaps we admit that this clause could have been drafted in a more clear terms. However, based on the intent...
I mean, it's clear to me. It's clear that lawyers drafted and they know what discovery means. I mean, discovery is disclosure of documents, and that's been excluded.
Yes, Mr. President, even if we take the legal definition between the distinction of discovery and disclosure, notable academics such as Redford and Hunter have recognized that discovery is different from disclosure.
Okay.
So even if parties had intended to exclude discovery, they did not correspondingly intend to exclude all forms of disclosure.
Okay.
And further, as I earlier pointed out to Mr. Weinbauer's statement,
Yeah,
the respondents
okay.
cannot, sorry, this is at page 31.
That's fine. Sure.
And because of this, it must be the case that the respondents understood not all and every form of discovery or disclosure should be excluded.
You're saying that because of what they said, there's a particular line you're referring to.
Paragraph 8 of which is the last paragraph. And it states, I understood the clause to exclude all types of requests for documents which go beyond requests for particular documents in very specific circumstances.
Okay, so but that's not the same as what you were saying in the earlier thing, right? I mean, this seems still a bit more restrictive than what your client had in mind, right?
It is true that perhaps Mr. Weinbauer's statement is a more restrictive construction of what is permitted, but we will proceed on the respondent's interpretation, which is taking the respondent's case at its highest, that only particular documents in very specific circumstances should be considered by this tribunal. However, the key reason why I'm pointing the statement to this tribunal is merely to illustrate the fact that the respondents cannot now say that they intended no discovery or disclosure at all.
Okay, so are the documents, what documents are you asking?
We are asking this tribunal to request for the disclosure of documents between the respondents and Superwines in their negotiations between January 2014 and July 2015.
That does not sound to me to be a request for particular documents in very specific circumstances.
We understand, Mr. President, that this may seem a little bit wide, but perhaps it is because of the circumstances where the parties operate that such a wide frame is necessary. First and foremost, the claimants are not aware of what exactly the list of documents that the respondents have in their possession. Further to that, it has been recognized that because of the informal nature of the wine industry, most contracts are not solidified in one document, but take place over a series of negotiations that parties exchange. And because of that, the claimants here are seeking for a wider ambit, and the respondents can choose what is relevant within this ambit to disclose to this tribunal. I see that my time is running out. If I could address this tribunal on the disgorgement of profits if there are no further questions for evidence.
I think for today we can let the time run a bit. I just want to make sure you test all your arguments out.
All right.
So just go ahead. If you have something else to say on this, just go ahead.
All right. So then I will continue further on document disclosure. In this case, if we were to look at the relationship between Superwines and the respondents, they had first met and begun negotiations in January 2014, and this coincides with the time frame that the claimants are asking for. And subsequent to that, there was quite a bit of back and forth between Superwines and the respondent as to whether or not they would enter into a contract for the sale of wine. This was because the respondents at that time had already had relationships with several customers, and its supply of wine had been locked up with several customers. So its discussions with Superwine centered around how they would structure the relationship the respondents had with its other customers.
But your claims for loss of profit, right? So isn't all that you need just the invoices that document the final price that the respondent transacted with Superwines at?
Yes, Mr. Arbitrator, it is true that we are claiming for loss of profits. However, that is not the only documents we need, because the claimants understand that a claim for the profits of the respondent is an exceptional remedy, and because of that, we want to prove exceptional circumstances due to the intentional nature of the respondent's breach. And because of this need to show the intentional nature of the respondent's breach, we do require their correspondence with Superwines above and beyond merely the
Isn't that
exact.
just fishing? Basically, you don't really know whether there was an intentional breach, but now you have to figure out whether you can support your claim.
And I mean, it isn't just the fact that, I mean, we know for certain that they engaged in contract negotiations. That fact is enough to let us know that it couldn't have been a inadvertent breach, right? It has to be intentional.
Yes, Mr. Arbitrator, I will address your question before the earlier question. It is true that to prove intentional, it is just an act of breach. However, in this case, the claimants understand that the respondents have more than one customer, and we are not their only customer, and because of that, we need to show that they sold the wine to Superwines instead of the claimants, rather than any other of the respondents' customers instead of the claimants. And if I may point this tribunal to page 26 of the record, this is the respondent's statement of claim at paragraph 12. If I may just quote to this tribunal, it states that the respondents had intensified discussions with Superwines after the claimants allegedly ignored the respondents' information on the bad harvest. So to address the earlier question on whether or not this is a case where we didn't know whether the breach was intentional with regard to Superwines, this statement from the respondent's own statement of claim is clear enough to show there is a correlation when they breached their obligations with the claimants and intensified their discussions with Superwines. And it is because of this that we are seeking the documents at that relevant time.
So it is a statement of claim.
This is the respondent's answer to the statement of claim. And I see that the concern is directed mostly towards the issue on the profits that the claimants are seeking. And so I will turn now to...
I'm just wondering, I think the point that what the arbitrator is saying is that there's no dispute that it's intentional. I mean, it has to be, right? I mean, they entered into a contract knowing that they not enough already. I mean, we are satisfied with that, so why do you need anything more?
Yes, Mr. President.
Or rather, you can make submissions on that, right?
This is because, Mr. President, the claimants are seeking the profits the respondent got from Superwines and not any of the other customers that the respondents had. So in order to show that there's some sort of relationship between the respondent's breach to the claimants and its eventual contract with Superwines, it is necessary to evaluate the negotiations that went down between the respondents and Superwines, as opposed to any other of the respondents' customers which may have been relevant for the claimant's claim for damages. Turning to the issue of a gains-based measure of damages, the claimants acknowledged, members of the tribunal, I see that my time is up.
Yes. I mean, don't drag lah. Just
Right. Thank you, Mr. President. The claimant here acknowledges that a gains-based measure of damages is not a conventional remedy under the CISG. However, it is the claimant's position that this tribunal is not precluded from ordering this measure of damages. This is because this remedy has been awarded by tribunals applying the CISG. Notably, the Stockholm Chamber of Commerce in the pressure census case has ordered a gains-based measure of damages. Further,
I mean, they could be wrong. I mean, can I first ask under what provision are you asking for gains-based damage?
Mr. President, we are asking for a gains-based measure based on Article 74 of the CISG.
Okay, what does it say?
Article 74 states that
Karen, just tell me what.
this is at tab 5 of the bundle. It states that the
Which
loss...
is what color tab? Because these bundles have no numbers in there.
My apologies, I will direct to the color.
Okay, it's green. Is it green? Okay, yeah. Found it. Yes.
Article 74.
Yep.
Article 74 states that the losses claimed by the aggrieved party is pegged to the loss that it suffered due to the breach.
The doesn't sound like gain-based to me.
Yes, Mr. President, while it may seem counterintuitive that a gains-based measure of damages falls under a loss, in this case, the claimants are seeking that the respondents' benefits or profits from their breach should be referenced in evaluating the loss that the claimant suffered because of the difficulty in the claimant's ability to quantify its losses. And if I may take this tribunal through the record in determining whether or not the loss in this case was difficult to quantify, first at page 50.
Can I just ask, at the point in time where they had this, obviously the travail, does it say what they were envisaging when they put it in Article 74? Was there any sort of gains-based measure ever contemplated?
When the CISG was drafted, a gains-based measure of damages was not contemplated because this measure of damages had not yet emerged in international jurisprudence for a measure of damages.
Okay, so now then the question is, what kind of way do we interpret the CISG? Is it this is the usual divide, for example, US law, right? I mean, what is the Constitution? What's the CISG? Is it a living instrument that has to move with the times? Or is it something that we look at drafters' intent and that we look at what stated at that point in time? I mean, what is the way to interpret the CISG?
Mr. President, if I may direct this tribunal to Article 7 of the CISG.
Yeah, okay.
7, more specifically 7.2 of the CISG. It states that the provisions of the CISG should be interpreted taking into consideration the international character of the convention. And because of that, this allows this tribunal to take into consideration developments in the law of contract for
Is that how the commentators have interpreted Article 7?
Yes, Mr. President. Notable commentators to the CISG, namely Professor Schwenzer and the late Professor Schlechtrim, have recognized in their commentary to the leading commentary to the CISG that a gains-based measure of damages should be permissible under.
No, sorry, I'm asking about interpretation of Article 7. As in, I'm asking, you say that Article 7 shows that essentially we have to move with the times and we can incorporate new developments that were not contemplated by the draft of the CISG. I'm saying, are there any commentators that support your interpretation of Article 7?
Yes, Mr. President, commentators have recognized that Article 7.2, in its recognition of the international character of the convention, allows tribunals to take into consideration.
You do mean 7.1, right? Or 7.2?
7.2.
Okay, I see.
Recognizes that in the international character of the convention does take into consideration developments in the area of contract law around the world in determining whether it should be incorporated under the CISG. This has been championed by Professor Seidorf, who is a special rapporteur to the CISG.
Carry on. So you're saying Schlechtrim and Schwenzer support the view that 74 can include a gains-based damage, and what is the test on which when can we order gains-based, based on what they say?
Mr. President, when the leading commentary to the CISG evaluated whether a gains-based measure should be awarded in individual cases, they considered the difficulty in quantification to be the main factor of consideration when a tribunal decides whether or not it should order this remedy. However, on a survey of different academic authorities, the claimant is suggesting that we put forward a test that is more encompassing to the international
You
jurisprudence.
said there were some cases that allowed this kind of remedy, right? How did those cases deal with it? Because academic commentators are not looking at specific fact situations.
Yes, Mr. Arbitrator, the case that I cited earlier is the pressure sensors case, and in that case, it was stated because of the difficulty in evaluating the claimant's loss, they had awarded a gains-based measure of damages. And because of that, difficulty in quantification is one of the key factors the claimant must prove in
What
order.
does difficulty in quantification actually mean?
Mr. Arbitrator, this means that the claimant's loss must have a high degree of speculation such that we cannot definitively prove in an absolute sum what the claimants had lost due to the breach of the respondents. And if I may take this tribunal through how the claimants in this case are proving this element, if I may refer this tribunal to page 53 of the record, paragraph 6. This is procedural order number 2. Beginning from the second line at paragraph 6, it states that this is the claimant's pre-order scheme it has with its customers. So if I may read to this tribunal, customers who are members of the Claimants Collectors Club can indicate their pre-orders. how many bottles of a particular wine they are willing to buy if the price is not 5% higher. According to the conditions applicable in these pre-orders, a customer is required to take at least 70% of the bottles they are offered if the price is as of indicated. And the second pre-order scheme is that if the wine is offered at a 50% higher than the previous year, then the claimant must guarantee a delivery of 90% of the orders. So because of the speculation in allowing the claimant's customers to determine exactly how much they want to take based on the fluctuations in the prices of wine from year to year, this pre-order scheme involves a great degree of speculation. So there are two key areas where the speculation comes in. First, that the price of wine from year to year varies. This is because the quality of the grapes and the corresponding price in which the wine is valued at would vary every year. Further to that, the customers are obligated to take between 70 to 80% or refuse the entire order in the event that the price is not to their liking. And because of this, there's a great degree of speculation as to how much exactly the customers...
Is there great demand for this wine?
Yes, Mr. Arbitrator, there was
So
great
could we assume that all the wine will have been sold to someone, anyone?
Yes, Mr. Arbitrator, it's true that we can assume that all the
Can
wine...
we ascertain the price at which such collectors purchase this wine?
No, Mr. Arbitrator, although we recognize that the most difficulty is because there's a market value of the wine available. This is found at page 55 of the record. However, it is noted that this market value of the wine is pegged to a very specific class and it's a very small sample because it's individualized customers by specialized retailers. And because of the small sample available and the difficulty
See, why don't we just ask them for the price at which they sold their bottles to Super Wines, multiply it by the number of bottles you have gotten, and then get that to evaluate your profit, the loss of profit.
Yes, Mr. Arbitrator, that is the measure of damages that the claimants are seeking in this case, the measure of the premium Super Wines paid to the respondents, pegged to the number of bottles they eventually delivered, which is, they didn't deliver to the claimants, which is 5,500.
So why is this a disgorgement?
This is because instead of claiming the exact loss of profits the claimants suffered due to the non-delivery, we are claiming the profits the respondent got from Super Wines. And because Super Wines is the third party to this suit, and we are actually seeking for the profits that the respondents earn from its customers as opposed to our own specialized losses. Further on the issue of difficulty, procedural...
Sorry, I actually meant the price, you deduct the price at which you would have purchased from them.
Yes, yes, Mr.
So
Arbitrator.
why is their profit pegged to the price at which you would have purchased from them, minus the price at which it sells to Super Wines?
Mr. Arbitrator, the claimant's claim in this case is the price that Super Wines had paid for the wines from the respondent minus the cost price that the claimants would have paid for the wine.
Would you have purchased it at cost price?
Yes, cost price in terms of how much the respondents would have offered the claimants for the wine. This is because at page 62 of the record...
You can continue.
Okay, Mr. Arbitrator. Turning to page 54 of the record at paragraph 13, this is an explicit recognition in procedural order number 2 that it would be extremely difficult to quantify the claimant's losses. And continuing to page 55 of the record on the same paragraph, it states that it cannot be stated with any certainty whether some of the claimant's customers which had made no pre-orders would have bought the same amount they finally bought if a mixture of both wines had been available. Also, we recognize that the respondent's wine occupies a very specific and specialized position in the market for wine. This is because they are the only wine that has won an award for the past 5 years in the region. And because of the nature of the respondent's specialty wine, it is very difficult to peg the amount of losses the claimants would have suffered due to their breach. Turning to the next level of complexity in this difficulty to quantify, it is stated at page 54 of the record that the pre-orders the claimant got for the wine from the respondents were of a greater amount than any other year, 20% higher than 2013. And this was before the claimants even stopped pre-orders due to the fact that the respondents stated they would not be delivering the wine. In light of this difficulty, we urge this tribunal to order to adopt a flexible approach in the calculation of damages by taking into consideration the respondents' profits from their breach of contract with the claimants.
Counsel, can I just ask? I suppose we're just trying to cut through a bit. You know what price you contracted to buy the wine for, right? From
Yes.
respondents. And so, one way to calculate it is obviously we look at how much you pay times the amount of bottles, which is fixed, right? We know how many bottles you ordered. Is that right?
Yes, we do.
And you know what price you were going to sell at, right? Do you know what price you were going to sell the wine at?
At the point, the procedure orders and the record makes no reference to how much the claimant eventually sold the wines at, because the scheme of which the pre-orders operate allows for more than one type of wine to be sold in a package. And because of that, there's no clear indication of the exact amount the claimants would be selling the wine.
But that's something you can determine, right? I mean, then you can persuade us then that what you surely guess the claimant, you know what you were going to sell the wine at, right?
Yes, Mr. President. The claimants have undertaken that if this tribunal finds a disgorgement is not appropriate, we will undertake the burden to show exactly the loss by stating to this tribunal how much we would have sold the wine for. However, at the present moment,
Isn't it incumbent on you to establish, or I mean, surely you have projections of how much wine you are intending to sell, how much you are expecting to sell it for, and isn't it incumbent on you to establish that you actually suffered the loss rather than just say, oh no, we just take whatever profit they would have made?
Yes, Mr. Arbitrator, it is true that it is claimant's burden of proof to show its loss. However, in this case, because of the extreme difficulty in quantification, we are suggesting that in a flexible approach, we take into consideration the respondent's profits it earned from breaching the contract. However, again, at procedural order number 2, paragraph 2, this is at page 53, the claimants have agreed that if this tribunal does not agree that a disgorgement of profits should be awarded, we will undertake the cost and submit to this tribunal on a mode of calculation based on the projected amount of orders we would have obtained. And if I may be of no further assistance, this concludes my
Thank you.
submission.
All right. Here for the response.
Oh, sorry, hold on. Let me move that.
Same thing like me, all of you just would drag it. We want to hear to be drag, but just you just answer our questions. Go on. Don't be so much about time.
Members of the tribunal, as stated, my name is Sean Sim, and together with my co-counsel, Ms. Ni Qian, we act for the respondent, Vino Veritas Limited. I will speak for 16 minutes and reserve a further minute for rebuttal, while Ms. Ni will be speaking for 12 minutes, and she too reserves a further 1 minute for rebuttal. Members of the tribunal, contracts are broken for various reasons, and my client accepts that his conduct has not been exemplary. But despite the unexpected shortfall caused by the inclement weather, my client is agreeable to compensate the claimant for the loss of profits that suffered as a result of our failure to deliver. Now, however, the claimant seeks to punish my client by claiming for itself the profits we made
Your client is prepared to compensate the claimant
for the loss of profits that resulted from our breach.
And when those are your instructions.
Our instructions was to challenge the claimant's method of damage quantification, that of disgorgement of our claim as a claim for our profits that we made from super wines.
So y'all don't dispute the fact that y'all would be liable.
Yes, we do not dispute the fact that we accepted that we have breached the contract by failing to deliver 5,500 bottles of wine to the claimant. Now, and since we
Sorry,
say
but you agree to a compensatory mode, you're saying that's
certainly, Mr. President, and we are disputing that disgorging our profits is the appropriate measure as suggested by the claimant. In fact, we will say that this is not the first time the claimant has sought to punish my client, because in December 2014, the claimant obtained an injunction preventing my client from selling our wines. And despite citing urgency as a reason for obtaining the injunction, they left the injunction idle for a whole 7 months while they went ahead to obtain substitute wines for their customers.
What do you mean by they left it idle?
They did not discharge the injunction, they did not start an arbitration, Instead, they left the injunction there and went to seek substitute wines, leaving us unable to do anything with
But
that
if
fine
they
cause.
obtain an injunction, you expect them to go and discharge it after that.
Certainly, but they did not respond to our letter for arbitration as well, Mr. Arbitrator, which is an issue that co-counsel will later canvass in her submission.
But what do you expect an applicant for an injunction to do with the injunction once he has obtained it?
Once it should have, in good faith, sought to discharge the injunction once it obtained substitute wines, or in the event that it did not obtain substitute wines, seek an arbitration so that we can quickly resolve the dispute. In this case, it did neither of those. And it's against this backdrop of events that I'll be making three submissions. First, that should this tribunal find that a claim of disgorgement should be ordered, it has no power to order document disclosure because the parties have agreed not to do so. And second, even if the tribunal has the power to do so, it should not order disclosure because the claimant's requests do not fulfill the requirements laid out in the IBA rules. And third, a disgorgement of my client's profit should not be ordered because it is inappropriate to do so under the CISG, nor is it appropriate to do so on the facts. I now turn to my first submission. As a preliminary point, the claimant has not disputed that the tribunal's discretion to order disclosure can be superseded by parties' agreement. This is pursuant to Article 28.1 of the Vienna Rules. Therefore, the crux of this issue, as rightly pointed out, is with the interpretation of the term "no discovery shall be allowed." While we do not contend the claimant's use of Article 8.1 of the CISG, we contend that the parties intended to exclude all forms of document disclosure and not just wide-ranging extensive discovery.
Can you deal first with the point? I mean, of what your own client representatives said. I mean, they seem to be willing to restrict themselves to that. Do you accept that? That there is a power to disclose something. It's just we are just fighting over what does the word, what particular document, limited circumstances mean.
Certainly, Mr. President. Now, the claimant alleges that the statement found at page 31 by our ex-CEO, Mr. Weinbauer, is a concession of my client's awareness of the claimant's intention. However, this is untrue, because Article 8.1 of the CISG states that the counterparty must know or could not have been unaware of what the maker intended. Here, that would mean my client must have known or could not have been unaware that the claimant intended to exclude only extensive discovery. Now, Mr. Weinbauer's statement does not show that he was aware of the claimant's intention. At best, it shows that he was aware of the varying standards of disclosure in the international regime. At no point during contractual negotiations did the claimant make clear or make any reference to the fact that he was trying to exclude all forms of discovery. What the claimant cited earlier in her exhibit by witness statement Ms. Kimley has not been shared with the respondent during negotiations.
I'm just taking a practical approach here. I mean, there's obviously no discovery. Yeah, I mean, at first it's trying to say no discovery. I accept that that's not what you understood. It seems quite clear. But your client has said, I understood that all discovery is excluded, save where, and that's what it says here, right? Where requests for particular documents in very specific circumstances. So insofar as you yourself, your own clients accept that, why can't we agree that that lower standard is what the parties had agreed to? Do you first agree that this line encompasses the correct interpretation of the clause, no discovery?
No, we do not agree that this line.
But why? Your clients say that.
Because on another reading of this term, we will actually say that this statement made by Mr. Weinbauer is rather ambiguous. We are unable to clarify what he actually meant because he's no longer working for my client's company. And in fact, when he says that I understood the clause to exclude all types of requests which go beyond requests of particular documents, it could be read that it will exclude all types of document requests, even those that exclude particular documents in very specific circumstances. And as Mr. President earlier used the word save for, Mr. President had to substitute the word which go beyond for the word save for specific discovery. And this goes to show that this statement in itself is rather ambiguous, and instead we should consider other circumstances to determine the party's intention. And what we say is that the parties could not have intended to exclude exclude only specific discovery or specific disclosure because it is something that has already been excluded in international arbitral practice. If I may refer this tribunal to page 9 of the record. At page 9 under Article 20, now the fourth line of the paragraph, it states that any dispute shall be settled in accordance with international arbitral practice under Article 20, fourth line. So under international arbitral practice, it is tried that extensive discovery are already deemed inappropriate. And this was stated by the IBA Review Subcommittee and affirmed by Professor Zubahaila in his commentary on the IBA rules. Mr. Gary Bond shares this view and states that when parties agree to international arbitration, they do so with the expectation that it will not involve extensive discovery. Therefore, parties being legally advised, as pointed out by Mr. President, could not have negotiated a term that excludes extensive discovery, which would have already been excluded in any case, even without stating that in the contract.
Is that really true? I mean, I understand that it's not something that arbitrators generally do. Extensive discovery is not something that we do as a matter of course, but is it really outside the powers of a particular arbitrator? Perhaps you happen to be American and all three of them American, to then say, well, yeah, I'm going to alter it to be wider. They have the power to do so, right? Power.
Mr. Arbitrator, we would say that certainly an arbitration tribunal has the power to order disclosure. However, this is
Even
limited.
extensive one.
No, not extensive one, because this has been clarified by the IBA rules, which is the international standard
Not
for
binding.
evidence.
And then
They are
I
not.
can-
However, this has also been echoed in the Vienna rules, and the IBA rules.
What does the Vienna rules say?
Vienna rules, Article 28 of the Vienna rules. I believe it's in
Yeah,
You have
fine.
it.
Article.
You have it in the bundle.
Yes, we have it in the bundle.
Yeah. It's text.
Apologies, Mr. Tribunal. We were under the assumption that you guys will not be receiving the complete bundle, but only the questions.
That's fine. What do you tell me? Just read out what it is.
Essentially, Article 28 and 29 of the Vienna rules states that the tribunal may only order document disclosure should it find it necessary and material to the dispute.
Okay,
And
so
this-
what necessary material? Everyone has a different view on that, right? I mean, somebody, as I said, if I'm a US trained lawyer, I can say, no, of course it's necessary. I mean, yeah, we need to have everything before me. It's a very vague standard. I mean, I'm talking about power here. I mean, surely you're not saying that I cannot do it based on this because the tribunal is deciding what is necessary material, right?
Certainly. So, should this tribunal, if an arbitrate in a hypothetical situation where arbitrator finds that it is necessary within his understanding, he certainly can have the power. Does have the power to order
That's my
disclosure.
point. I mean, if any individual arbitrator applying the Vienna rules may come to the conclusion, I want extensive, they can. And if that is the case, then this clause is still useful, even if it just meant to exclude extensive discovery, because it makes clear to the tribunal you are not empowered to go that far. I mean, whereas if it's not there, I mean, they can. So now it does curtail the tribunal, doesn't it? So it's not totally as meaningless as you say it is.
Perhaps, however, Mr. President, although we note that the IBA rule is not binding on the tribunal, the IBA rules is meant to supplement the Vienna rules, and the IBA rules doesn't just try to explain,
Why do you say that it's meant to supplement the Vienna rules?
because the objective of the IBA rules, as stated by the IBA Review Subcommittee, says that it's meant to help arbitrators understand certain provisions in regards to the taking of evidence in
Sure,
arbitration.
that's fine. I mean, the IBA rules don't apply to this contract, right?
The IBA rules do apply to this contract because the parties have not expressly agreed to exclude it, and that's the position which has developed the development of IBA rules.
Really? So it applies if you don't exclude it.
If it's not expressly excluded, it can be applied to the arbitrator. And
Can
there
it
are
apply or
two
does
reasons.
apply?
It can be applied.
Can
My
be
apologies.
applied. Yeah, of course, it can be.
And there are two reasons why it should be applied in the present case. First, because as stated by the parties in Article 20 of the contract, it is to be disputes are to be settled in accordance with international arbitral practice. And the IBA rules reflect best international practices. Second, it is a compromise between common and civil law jurisdiction on the issue of evidence taking. Both the parties come from various different jurisdictions, one common and one civil. and therefore we say the IBA rules should be applied. And in that sense, it aids the tribunal's understanding what necessary and material mean under the Vienna rules.
Okay, so do you have any other circumstances we also look at?
Sure, Mr. Arbitrator, advisor of tribunal, if you are not with me that this tribunal has no power to order document disclosure, it should nonetheless not order disclosure because the claimant's requests do not meet the cumulative requirements laid out in the IBA rules. The IBA rules mandate that a request has to be sufficiently specific, not impose an unreasonable burden on my client, and also has to be material to this dispute. First, we say that the claimant request is not sufficiently specific because they have requested for all documents between 1st January 2014 to 14 July 2015. This is 1.5 years worth of communications between the respondent and Superwines. However, it has been clarified by this tribunal that Superwines' offer was only made on 25th November 2014, 11 months after the stated request of 1st January 2014, and it was accepted in less than a week by my client on 2nd December 2014. Thus, the claimant is seeking 1.5 years worth of documents when he could have requested for merely a week's worth of document to ascertain the price. In fact, if the claimant was truly concerned with the price and quantity of the wine sold to Superwines, and as Mr. Arbitrator pointed out earlier, it could have simply asked for an invoice of the sale and purchase between the respondent and Superwines to ascertain quantity and price sold.
So that's not why that's not the only thing that they say is important, right? I mean, they also talk about something regarding the intentional nature or that they assess with what you're selling to the other customers.
Certainly.
Can you address
Certainly,
that?
Mr. President. And Mr. Arbitrator earlier noted, by saying now at this present proceeding that they want the document to determine whether or not the breach was intentional, it can be very well said that their request is actually a fishing expedition as defined by the IBA rules, because there is nowhere on the statement of claim did the claimant say that they want the document to determine whether or not our breach was intentional. And under the IBA rules, fishing expeditions are considered are requests for documents that are not for the purposes of a stated claim, but rather to tease out alternative allegations from the documents disclosed.
I think the point the claimant made was that in order to succeed for their claim for damages with reference to your profit, they need to show or establish some form of sharp practice on the part of your client, which is why they say that the correspondence may be relevant to establishing that point.
Certainly, Mr. Arbitrator, we note that that is the claimant's argument. However, as stated, this argument and this purpose for requesting the document has not been reflected anywhere in the claimant's statement of claim.
But you accept that your client's behavior may be relevant to the appropriate measure of damages?
No, it would not be relevant to the appropriate measure of damages because we are contending that the disgorgement of profits should not even be considered by this tribunal in light of the compensation measures available to this tribunal today. And seeing that that's the concern, I shall spend my remaining time addressing this tribunal on the issue of disgorgement, which will also show whether or not, we should also clarify whether or not those documents are material to the dispute. Now, the claimants relied on Professor Swenzer, on the works of Professor Swenzer, yet it should be noted that Professor Swenzer and Professor Harchem both accept that punitive damages are not available under Article 74 of the CISG. Instead, Professor Swenzer justifies her argument using notions of compensation rather than punishment. And the reason why she did so was because Article 74 was drafted for the sole purpose of compensation.
But isn't that precisely what they're asking for? They said, I want to be compensated, I don't know how I'm going to be compensated, so let's use your profits as my compensation. They're not saying, let's punish the respondent.
Certainly, Mr. Arbitrator. However, the claimant here obtained substitute performance and made profits out of those substitute wines obtained from Vigno Belia Limited. And if I may refer this tribunal to page 54 of the record, paragraph 10, fourth line from the bottom, it states, a considerable number of claimants' customers were willing to do so, and in the end accepted a mixture of Martha Weltin from my client and from other top vineyards where the claimant had bought 5,500 bottles from. Now, at least on the outset, a claim for my client's profit will be akin to overcompensation, unjustified under Article 74. However, we know that counsel for the claimant argued that they indeed suffered a loss of profit because they could have sold all 10,000 bottles of wine bought from my client, as well as the 5,500 bottles sold from Vic Nobilia. That in that situation, they argued it would not be overcompensation, but rather a loss of profits. However, we say that their claim is merely speculative. The claimant has consistently sold between 7,500 to 8,500 bottles of my client's wine for the past 6 years. Yet now they insist they could have sold 15,500 bottles of wine, almost twice.
Is there any real dispute that if the claimant had wine in their hands, they would not be able to sell it? Because I mean, my understanding from the record is that the demand for wine was quite exceptional that particular year.
Certainly, Mr. Arbitrator, there is no dispute that if the claimant truly had 15,500 bottles of wine in their hand, they could have sold those wines. In fact, wine of such good vintage could be kept for a few years before selling off. However, in that situation, we say the claimant would not have the finances to purchase both batches of wine from my client as well as Vic Nobilia. Now, if this tribunal would turn with me to page 58 of the record, paragraph 38.
Why is their financial state relevant to the claim?
Because they would not have money to purchase batches of wine from both my client and from Vic Nobilia. And therefore, we are contesting that they would never even have 15,500 bottles of wine to sell should my client have made good on this delivery. The only reason why they had money to pay Vic Nobilia Limited is because they didn't pay us. And according to paragraph 38, the tribunal clarified that all of the claimant's liquid financial assets have been tied down in an investment. They would never have the money to purchase the extra 5,500 bottles of wine from Vic Nobilia. The only reason they can have they do that
Actually, isn't that a bit speculative? Because it would depend on their terms of payment. I mean, if Vic Nobilia is prepared to take deferred payment terms and prepared, I mean, as unlikely as it may be, to deliver the wine and take payment, let's say, a month down the road.
certainly we accept that it depends on the payment term on Vic Nobilia and the claimant. However, if that is the case, then they should produce those documents for this tribunal to decide what were the payment terms. But without any additional facts to help us in this dispute, this tribunal can refer to Article 58 of the CISG, which states that payment must be made on delivery.
Wait, before you go there, are you saying that Professor Swenzer is taking the position that the gains-based damage awarded can never exceed the level at which the compensatory principle would have given damages? Are you
Yes.
saying that that's what she said?
That is Professor Svenzer's position that if disgorgement of the respondent's profit was to be ordered by this tribunal, it cannot be for a punitive purpose because that's not allowed.
Punitive is not the point. I mean, that doesn't mean I order more means it's punitive. I mean, I'm just saying, is she saying it can never go above the measure of compensation?
That would appear to be her position, Mr. President.
From your reading of the word punitive.
No, when she states that the parties are that. Sorry, I do not have Professor Swenzer work on hand, Mr. President, but it would appear that she justifies her work based on notions of compensation, and she accepts that overcompensation should never be granted under the CISG. And in this case, if we were to grant the extra 5,500 bottles of wine times the number of times the price that we sold the wine for, it's quite a substantial
Maybe
amount.
just maybe after we figure out what your profits were, deduct it from minus off their profits from selling the Nobilia wine or whatever it was, the substitute wine, and then award them the remainder as damages.
That will certainly be an option to offset the two different amounts, Mr. Arbitrator, but we say there is no need to go that far because on the facts, we can determine the claimant's loss of profits. If I may refer this tribunal to page 54 and 55 of the record, where there will be information to assist this tribunal in calculating the claimant's loss.
If we find out that, I think you need to deal with the argument that losses, compensation damages can't be calculated. Because if they are right, you can tell me to the cows come home that I think that it will be so much and you will exceed. If we give you, my profits will exceed that. But if I accept that it cannot be calculated, I cannot make a finding that first thing you need to do is to tell me why they are wrong to say it cannot be calculated. Because if it cannot be calculated, I cannot find that it will exceed. You see what I mean?
Yes.
So,
Mr. President,
can you tell me why they're wrong?
the claimant is wrong to say that damages cannot be calculated.
So this is the key battleground, isn't it? Not whether or not it will exceed. The key battleground is whether it can be calculated. If it can be calculated, then I'll give it to them. I mean,
Yes.
if it cannot be calculated, then your argument is out the window.
Certainly, Mr. Arbitrator, we're responding to a point in which they say that it will not be overcompensation and not speculation.
Okay, yeah.
But certainly, Mr. President, you are right to say that compensation, whether or not their damages can be calculated, should be the main focus of this dispute.
Sure.
And at page 54 of the record, paragraph 13, it states, it will be extremely difficult, though not impossible, to calculate the actual loss of profit made by the claimant.
Okay.
Although the tribunal did not go further to clarify how it would not be impossible to calculate the damage, we would suggest that the loss of profits the claimant suffered due to our breach can be calculated on the facts. And as stated, page 54 and 55 is where we can find information to calculate the loss of profit. And at page
But
54,
counsel, don't you accept that at the end of the day, justice has to be flexible? I mean, if, for example, your claim is $1 million, and to calculate your damages is $10 million, are you still telling me we have to go through the whole rigmarole of calculating just for the sake of the compensatory principle? That doesn't make sense. I mean, there has to be a limit. I mean, just because it can be doesn't really mean that we have to give it. If there are sufficient difficulties with computation, that should suffice, right?
certainly, Mr. President,
Yeah.
we note that in the hypothetical situation stated, it will clearly qualify as an exceptional scenario in which the disgorgement of profits should be ordered.
Mhm.
However, on our present facts, the situation is not so exceptional. In the pressure census case cited by the claimant, the parties in that dispute had shared a confidentiality agreement, and the buyer, who was the breaching party, breached that confidentiality agreement, took those technical information belonging to the seller, and produced competing products against the seller. And in the Stockholm Chamber of Commerce ordered the disgorgement of profits because in that case, the damage caused by a leaking of the seller's confidential business information was almost impossible to quantify, and that qualifies as an exceptional scenario in which intangible assets are involved. Here, the loss of profit can be easily calculated because we know the price in which they bought the Vignolia wine and the price in which they would have bought wines from my client. What is only missing is the price in which they would have sold. And as earlier pointed out by Mr. Arbitrator, that the market value of our wine sold by a third-party retailer is 90 to 100 euros. And though the claimant will say that this is insufficient to calculate their profits due to their complex pricing structure, we beg to differ. This is because the 90 to 100 euros available as data in the market should generally suffice to tell the tribunal how much our wine could have been sold for. Third part, it's difficult to imagine a scenario that our wines be sold for between 90 to 100 euros. The claimant could have sold it for 200, 100 or for 50. It's hard to see how this is the situation. It must have been within that range.
But we can't, you see. I mean, the whole problem is that tribunal is not allowed to guess. We can't just say, oh yeah, that's an estimate, so we make an assessment on estimates. I mean, that's not how the law works, right? I mean,
Certainly.
we have to look at what they would have sold. Even if you're saying one bottle is 90 and they would have, in truth, actually, if we spend the whole time finding what it is, theirs is 75 or 80, right? So $10. But you multiply by the amount of bottles, it makes a difference. And the tribunal can't do this kind of rough justice of, oh yeah, let's just use a number, that looks fair, let's look at the market value. That's not how assessment of damages are done, right?
Certainly, Mr. President. Two quick answers to that. I see that my time is up. I will briefly address this question. First, pursuant to the CISG advisory opinion on Article 74, it states clear that the tribunal need not be able to calculate with mathematical precision the loss suffered by the claimant. At this stage of the proceeding, as long as there are numbers for this tribunal to work with, it would suffice. Further, if this is the President's concern is with the exact number, a quantum expert could easily be hired to determine the price sold by the price in which the claimant could have sold our wines for. And because of that, we say that it's
I think it
possible.
goes back to the President's question earlier.
a quantum expert is appointed, it's going to cost a lot. How much is their claim for? Can we really justify getting a quantum expert?
A quantum expert should be justified in facts because it is something that will easily resolve this dispute quickly without any need for further document disclosure, an aim which has been stated by both parties right from the outset 6 years ago, that any dispute should be resolved quickly and swiftly. A quantum expert would be able to do that to save costs for both parties.
I mean, if you just disclose your documents, I think that would probably be quicker, as we all know.
However, Mr. Arbitrator, we are not allowed to disclose the documents due to confidentiality obligations that we owe to Super Wines. And if we were to disclose documents, we might in fact find ourselves in a litigation suit with Super Wines, a prospect that we say places too unreasonable burden on my client.
Do we know how much you sold the wine for to Super Wines?
To Super Wines, no, that's the premium price which they are trying to seek. That
So
price,
we don't have
and we are not allowed to disclose. If I may know further assistance, this
I have a question. Well, I mean, it's just on the basic principle. Do you equate punitive with deterrent? Is it the same thing? Is the aim of deterring somebody the same as punitive?
although I have unable to assist thoroughly on this academic point, Mr. President, but we do know that.
The reason why I'm saying this is this. I mean, you say that we can't give punitive damages. Fair enough, fine. They don't give punitive damages, but it is just a sense of fairness. You have engaged in sharp practice. You've basically tried to make a profit by intentionally breaching a contract. And I think the law has to try to uphold bargains. So why is it not valid consideration to say that we give against-based damage so that to deter people from doing these kind of things? And it is compensation in a way, isn't it? Because what they are being compensated is the broken bargain. And we're giving them, we're taking away from you your benefit from the broken bargain. Is that not something that is fair and something that this tribunal should do?
Mr. President, if I have just one last minute to address this point.
Finish.
First, in the hypothetical situation that should a breaching party has intentionally with malice broken a contract, then perhaps we would not go as far as to say that the punitive damages should not be awarded. However, on our present facts, my client did not punitively or intentionally try to breach that.
You won't know until you actually give us the documents, you see. So if you accept that where there's malice, they are entitled to certain claim for whatever punitive damages, then maybe you should just give us the documents and we can make a determination whether or not there's malice and what they're entitled to.
Mr. Arbitrator, there will be no need to do so because on the facts it is clear that we have behaved in a very reasonable manner. First, this is for three reasons, Mr. Arbitrator. First, negotiations, as pointed out by the claimant, with Super Wine started in January 2014. And it was only in November that we found out about inclement weather. September, November that we found out about inclement weather. And throughout all these these months, we have already negotiated to a great level of detail with Super Wines. It will affect my client's reputation should then now we just reach all those informal negotiations that we had with Super Wines. And further, it should be noted that Super Wines ordered 15,500 bottles of wine from us. And we only, however, in light of the shortage and our desire to satisfy all customers, all existing customers, we only delivered about 1/3 of what Super Wines ordered. If we were truly concerned with earning a premium from the wines, we could have sold much more, but instead we only gave Super Wines 1/3 of the 15,000 bottles they ordered. And lastly, in line with my client's desire to satisfy all its customer, we allocated wine on a pro rata basis. It was not specifically against the claimant. And doing so, allocating wine on a pro rata basis is in line with industrial practice even in the event of shortages. And this may be found at paragraph 31 of the record. If I may be of no further assistance, this concludes my submissions.
31 what record?
31 of procedure order 2.
Yes.
Members of the tribunal, the claimant has 1 point to make in rebuttal. on the issue on whether or not the respondents intentionally breached its contract with the claimants to contract with Superwines. The respondents themselves have admitted or attempted to assert to this tribunal that they did not breach their obligation to the claimant to deliver to Superwines. However, if I may point this tribunal to page 26 of the record, at paragraph 12, this is their respondent's own statement of claim, answer to the statement of claim. And if I may quote at line 4 of this paragraph, as a consequence, the respondent intensified its discussion with Superwines, which had already been going on since the beginning of the year. While what the respondent has asserted is true, that the discussions were carrying on for a substantial amount of time, the respondent's own statement of answer to the statement of claim clearly states it was because of the claimant's behavior that they had then intensified their negotiations with Superwines. And because of this fact, it is clear we need the necessary documents on what occurred at that point in time to ascertain whether or not it was an intentional breach between the parties.
I mean, contracting parties are self-interested. I mean, they are not bound to act in favor of the other party's interests. So, I mean, if a better deal came along, what's wrong with them discussing with Superwines for more money?
Yes, Mr. Arbitrator, it is true that in a general commercial context, there is no duty owed to the other party. However, it must be noted in the CISG, the obligations between the buyers and seller based on Article 7 must be conducted in good faith. Furthermore, the relationship between the parties is not that of an arm's length dealing, because there's actually in Article 2 of their contract, the buyers and the respondent and the claimant have actually agreed to further each other's interest in a mutually beneficial relationship. So this was not a case.
Sorry, why is that not at arm's length?
My apologies, Mr. Arbitrator. Perhaps the case is not at arm's length, but rather it is not a case where the reputation or the relationship between the claimant and the respondent is purely that of very far commercial dealings where it doesn't matter that they breached the obligation with the claimant, as Mr. Arbitrator earlier suggested, but rather the relationship between the parties is such that their interests together in a long-term and mutually beneficial relationship should be that parties should not breach their obligations in bad faith. And if I may be of no further assistance, this concludes my rebuttal.
Members of the tribunal, I have one point of rebuttal. Sir, rebuttal. That we point out that in the contract between the parties, nowhere does it state that there's an exclusivity agreement between both parties. And since, as stated, as pointed out by the counsel for the claimant, it was only as a result of the claimant's unwillingness to cooperate that we had to look out for our own interests by engaging in talks, by intensifying the talks that we were already engaged in with Superwines. And it does not necessarily point towards the fact that we acted out of malice. Thanks.
See you on the next. Claimant, we hearing claimant for next question.
Members of the tribunal, good evening. My name is Wang Chen Lim, and I represent the claimant. And I will be addressing the final issue on whether the claimant is entitled to recover legal costs incurred in prior proceedings as damages. I'll speak for 13 minutes and respectfully reserve 1 minute for rebuttals.
Yeah, okay.
Members of the tribunal, prior to the present, the parties were involved in 2 sets of proceedings in the Mediterranean High Courts. The first set was an injunction obtained by the claimant to prevent the respondent from selling or contract to sell to third parties its wines that were supposed to be delivered to the claimant. The second set of proceedings was the respondent's application for a declaration of non-liability. This application was ultimately dismissed for the lack of jurisdiction because of an arbitration clause in the contract. Now, there are 3 questions for this tribunal to consider. Firstly, whether Article 74 of the CISG encompasses the recovery of litigation costs in the prior proceedings as damages. Secondly, whether the losses incurred by the claimant flow directly from the respondent's breach of contract and breach of arbitration agreement. Thirdly, whether the claimant's actions were reasonable and foreseeable in the light of surrounding facts. If I may turn to the first question, our position is that if I as claimant incur legal costs prior to the main litigation to compel or ensure performance, then I am entitled to the reimbursement of those costs as part of my damages for the
Sorry,
breach.
what's the first set of costs you ask?
The first, we are asking for both sets of costs.
No, I was asking what's the first set of costs. Tell me what exactly you are claiming for.
Mr. President, the preliminary issue is whether or not Article 74 would allow, in principle, the recovery of legal costs.
I'm asking you. You're saying there's two sets of costs, right? The first proceeding and second proceeding. First proceeding, what are you claiming? What do you want me to give you? What is
Yes,
the
Mr.
amount? What does it constitute?
Mr. President, we are claiming for the legal costs, that the legal expenditures that has been spent for obtaining this injunction
Okay,
in the
for
Mediterranean.
obtaining an injunction. Legal costs, just the legal costs.
Yes,
Okay.
Mr. President.
What's the amount?
15,000, Mr. President.
Okay. This. When you got an injunction, did you get a court order?
Yes, we did, Mr. President.
Has it been paid?
No, the cost order by the Mediterranean High Court was that the cost is bear by each party equally.
So the issue is determined. Well, you didn't get a court order by them to that for you?
Yes, Mr. President, but it's our position that the cost that was ordered by the Mediterranean High Court was subsequently a loss that the claimant suffered due to the breach of the
Sorry, the
contract.
cost that they ordered none. Right? You're saying the cost ordered by the Mediterranean High Court. The Mediterranean High Court did not order any cost, right?
The Mediterranean High Court ordered costs to be borne by both parties equally.
Okay.
So there are a sum of costs that has been borne by the claimant, and also the attorney's fees that's been incurred to seek for representation in the Mediterranean High Court.
I think the point that the president is making is that you've already had your chance to recover those costs. You've made arguments on it and you've lost. Why should we give you a second chance to claim those costs as damages when you've already, and it's been properly determined by a court that was in the best position to determine whether or not you should recover costs?
Certainly, Mr. Arbitrator, I have two responses to that. Firstly, the Mediterranean High Court did not consider points of merit when deciding the cost on the order. The cost order was awarded.
What do you mean by they did not consider points of
There
merit?
was no argument out by our colleagues when representing our clients at the Mediterranean High Court with regards to how these cost orders should be apportioned between both parties.
So that means they were negligent, and then that's why should we save you from your colleagues' negligence?
Yes, Mr. President. However, these are two distinct claims that we are asking for. We are not seeking this tribunal to grant us the cost that has been incurred. Rather, we are asking this tribunal to grant us the losses that we have suffered due to the actions or the unreasonable actions by the respondent in this case to breach the contract that both parties has agreed to.
Okay.
You commenced action, right, for the injunction.
Yes, Mr. Arbitrator.
I mean, so it makes sense that you bear the cost of commencing action, right?
Certainly, Mr. Arbitrator, but in the case law that we have, if I may, the case law that we have in the case law that we have, the German courts, the courts in Germany, Switzerland, France, and Finland, takes the position that the losses incurred by the claimant will be rightfully awarded as damages, with the controlling factor that such losses were foreseeable and mitigated sufficiently by the parties claiming for such damages.
So
Yeah.
what are they ordering firstly? Sorry, you're saying these courts have ordered something.
Yes, Mr. Arbitrator.
What is the fact pattern? Are you talking about subsequent court proceeding, arbitration proceeding? What is this previous proceeding you're talking about? Are you talking about interlocutory proceeding
Yes, Mr. President, we are talking about interlocutory.
in the same court,
proceeding. Not in the same court, Mr. President.
in a different court?
In the prior proceedings. If I may give you an
Yeah, why don't you
example.
tell me the facts? Yeah.
So in the Swiss Commercial Court, they ruled on the case of the government case where the claimant was awarded legal costs for pre-procedural services, including letter of demand, reminder notice, etc. Now, this court's decision was based solely on Article 74 of the CISG, ruling that such costs were loss that was incurred by the claimants during the contractual relationship between parties, which is highly similar to our fact where the injunction cost would not have arisen if the respondents did not intend to breach the framework agreement that both parties have consigned to.
Yeah, I mean, I can see on, say, letter of demand and things like that, because that's outside the court proceedings. But when a court of competent jurisdiction deals with a substantive application of an injunction, and they have obviously then the jurisdiction to determine the cost of that application. Letter of demand is obviously out. So I mean, I can accept maybe we can give you your cost for your letter of demand or whatever, but how you are essentially asking us to interfere with a competent court's ruling. They have said no cost for you, and you are saying, oh, you can ignore that. Is that wrong?
We note Mr. President's concern on the point, perhaps res judicata in this context. But if I may direct your attention to the authorities of West Tankers and Orleans, where the facts of the case was this: the vessel owned by the claimant was chartered by an Italian company, and it collided with a jetty. The chartered party had an arbitration clause providing for arbitration in London. However, the company's insurers brought court proceedings in Italy, and for the sum that they paid up. It was held in the English courts that the insurers were liable for the claimant's legal fees and expenses incurred in connection with the Italian proceedings. And this was where the courts made a distinction between claims on the same issue and claims of loss and cost here, because the English courts recognized the authorities of the Italian proceedings, however, see that the losses incurred by the claimant were losses that was in breach of arbitration agreement, and henceforth.
Yeah, but I think in the West Tankers case, the claim was made for damages upon breach of an arbitration agreement. But I think the point that you are advancing before us is that as a result of non-delivery, not a breach of the arbitration clause, but as a consequence of non-delivery, you have incurred legal costs, and you're entitled to recover that. Isn't that quite different? Because one can see how a breach of or commencement of court proceedings in breach of an arbitration clause is a loss that would naturally flow from the breach of the arbitration clause. But I don't see how that same reasoning applies for a claim for non-delivery.
But Mr. Arbitrator, if you take a step back from the facts and look at it in the perspective of, should this contract be fully performed by both parties, there will be no occurrence of such loss that will be incurred by the claimant. The very fact that we rely on Article 74 of the CISG, fundamentally because Article 70, the principle of full compensation that governs that guides Article 74, provides for the assumption that the parties incurring such losses should be compensated to the point or placed to the point where such breach did not occur and the contract is fully performed. So yes, perhaps Mr. Arbitrator's concern is that these two scenarios between our facts and West Tankers may not be the same, but if you look from the point of incurring losses, then we argue that this fully complies within the realms of Article 74 of the CISG.
Yes, but I think my concern, and I think Mr. President's concern as well, is that courts are an ordinary concomitant of the enforcement of your legal rights. And from our understanding, in all jurisdictions, they are treated on a parallel track. You never make a claim for costs in your claim for your infringement of your substantive rights. And this basically, I mean, the argument you're making basically blurs the distinction between both.
Certainly, Mr. Arbitrator. However, it is our position that this blurring between costs and the damages, especially in the context of the context of legal costs, is not a new issue, because if you study the arbitral tribunals, like for example in CITEC and in the ICC cases, such awards have been given in order to give full effects to Article 74 of the CISG. So in those cases, the positions taken up by the court are that the losses are something that the losses are issues that we seek to prevent, and when such losses occur, we will allow the injured party to seek for payments to restore them to the original position they have been in. If I may turn back to my submissions, on the point on on the second question, whether or not the losses incurred by the claimant flow directly from the respondent's breach of contract and the breach of arbitration.
Before you go there, can you tell me what's this second set of costs that you are claiming?
The
What's
sec-
the amount and what are they?
The second set of costs that we are claiming is an amount of 35,000 euros. And these costs consist of the filing fees and the attorney's fees for the claimant to defend the declaration proceedings initiated by the respondent in breach of arbitration agreement.
Was there a cost order made by the court there?
Yes, there was a cost order made by the court. Again, the presumption was that each party will bear its own cost.
This one's even clearer, right? It's a substantive application, declaration action. Totally different. Nothing to do with the arbitration agreement. I mean, they want to start, they got it wrong, but the court didn't choose to punish them. Too bad.
Certainly, Mr. President. But again, these cost orders was made on a presumptive position taken up by the Mediterranean High Court, and unfortunately, our client's representatives did not apply arguments against such a presumption.
So what would you say if the court did give you some cost there? You would still claim?
Yes, Mr. President, we would still claim because this cost does not cover the losses that we have incurred due to the unreasonable behavior by the respondent for taking unnecessary actions to bring these proceedings to court.
There's such a principle that if you take unnecessary actions, you'll be punished.
And I mean, the court can punish you, right? If the court thinks the action is unnecessary, then the court penalizes you with costs. But the court didn't see fit to do that. And I think the court declined jurisdiction on the basis that you should go to arbitration, right? So the court could just have said, you brought it in the wrong forum, you pay the cost.
Mr. Arbitrator, firstly, we did not bring the proceedings.
Or the respondent brought it in the wrong forum, so they pay you costs.
Yes, but unfortunately, that was not the situation that was awarded in the Mediterranean High Court. And we seek this tribunal to follow the directions provided in West Anchor case, where
I mean, my concern is one of interfering with jurisdiction, you see. I mean, now, let's just assume they say they give you some cost. They say, okay, I'm going to order cost on a party-to-party basis, certain amount. Then you say, you come claim the rest from us. Then essentially, you always get indemnity costs. And the court there, we wouldn't have known that. The court there has been totally overruled by us. In what position am I to overrule a sovereign court that has decided an application and said the proper cost order here is party-to-party cost of, say, $10,000. And then I am then supposed to come, even though this application is not before me, this declaration action is not before me, I'm going to say, no, you fools, you shouldn't have given 10,000, you should have given full cost of 20,000. And we're not overruling them in effect.
And they'll just refuse to enforce our award.
Yeah.
Right? If they're not happy with us, they just refuse enforcement.
Humiliated.
In excess of jurisdiction.
certainly, Mr. President, the concern here is that there will be an effect of negating the rule in the Mediterranean High Courts. However, when allowing the Mediterranean High Courts to rule on cost orders separately, and that allowing the situation of the claimant not being able to recover such losses that have been suffered, then the claimant will be placed in an unfavorable position, or in fact, unfair position due to unruly behavior of their contracting parties. And it's our understanding in the worldwide position that only jurisdiction that stands for such a principle is the American jurisdiction in the representation, in the case of Zapata Hermanos and Herbside Baking, where they adopt the American position of anti-user pay system.
Yeah, but Council, you're going further than that. You're really undermining the entire no full recovery rule, which applies in many jurisdictions. Because the point is that there are certain costs involved in litigation, and not many courts order full 100% recovery. But you are essentially asking for full recovery.
Mr. President, we are asking for the tribunal to consider awarding of damages, but it is not our position that
It is a sham. I mean, you are hiding it behind it and say, oh, it's damage. But the truth is, you are saying, I went and defended a claim, even though most national courts would not give me full recovery, they would at best give me party-to-party costs. If I hide it under a claim of damages, now I can get full recovery because I need to be fully compensated. But you would never have been fully compensated.
certainly, Mr. President, the principle of full compensation is not an unreasonable principle, and is not one that we extend to the unreasonable situation. It's a principle that is held back with two controlling factors, one of foreseeability and another of mitigation. And it's our position that the Claimants Act has fulfilled both requirements of foreseeability and mitigation. If I may first turn to the issue of foreseeability. Under Article 20, which is found at page 9 of the record, it is clear that both parties contemplated a situation of dispute resolution, and thereby the respondent cannot say that it was not foreseeable that such legal costs arising from the dispute resolution cannot be considered as damages.
I mean, you're saying that the potential wideness or width of your argument is reined in by the doctrine of foreseeability, right?
And mitigation.
But I mean, the way you're making your argument on foreseeability is, I mean, in any contract, wouldn't it be foreseeable that there would be litigation costs if there's a breach of contract?
Certainly, Mr. Arbitrator.
Yeah, so it's not really a limiting factor or regulating mechanism.
But the limiting factor will thereby fall onto the mitigation factors.
Okay, so your first one is not we can bin it.
In the context of recovering litigation costs,
We can bin foreseeability as a restriction on the
yes,
amount.
and this is a position taken up by Professor Slackstream on the discussion of contingency fee arrangement with regards to relations in Article 74 of the CISG. But so in this case, the real contention really is for this tribunal to consider whether the contingency fee arrangement that has been was foreseeable to the respondent at the time of contract. That should be the real question. And the test of such foreseeability is whether or not the respondent would have been aware of the situation for claimant to engage.
I mean, who can't foresee that you'll incur legal costs if there's a breach of contract?
No one.
No one, right? So, I mean, isn't that quite straightforward? That legal costs were foreseeable?
Yes, Mr. Arbitrator. In the test of foreseeability, the test is twofold. Firstly, that the kind of damages needs to be foreseeable, and the kind of losses needs to be foreseeable, and secondly, the extent of losses needs to be foreseeable. And it's our anticipation that the respondent will raise that the contingency fee arrangement was an extent in which it was unreasonable or not foreseeable at the time of conclusion of the contract. We think this is not a position that should be taken by the respondent for three reasons. Firstly, if the tribunal will turn with me to page 58 of the record.
It's okay. Why don't you just tell us quickly what are the three reasons?
Yes, Mr. President. So under the laws of the seat of arbitration, which is the Nubia, and under the laws in which the respondent is domiciled, which is Mediterranean, both jurisdictions accept and sees contingency fee arrangement as a usual way of dispute resolution or usual way to pay for dispute resolutions. And secondly, that the respondent themselves are familiar with such arrangement because they attempt to engage in one shown in page 59 of the record. Finally, the final fee in which we incur due to the contingency fee arrangement for both sums, 50,280 euros, is not an unreasonable fee, considering that the total claims in these damages runs up to 190.
How are the contingency fees calculated in this case?
The contingency fees can be found at page 7.
Meaning on 50, 30, in any event, 200. So they had to pay on top of the time cost, they paid another $45,000, is that right? So it's both,
Yes,
2 plus 4.
yes, Mr. President.
Okay. Isn't that a reward of sorts? The way it's drafted, it's not really a pure contingency fee. I mean, it's a. I have an hourly rate that I'm going to charge you for, but you're going to give me an additional reward if I do well.
Yes,
Isn't that what it is?
Mr. President. However, this hourly rate is just for one partner and a standard price of one partner in that situation. So we are not in a position. We don't believe that both cases will work just by one partner alone. We see this as a package that was presented to the claimant on the contingent that they are successful in terms of their litigation, on the process of litigation.
Do you accept that it's actually quite, just because contingency fees are foreseeable, the actual quantum can be something that is disputed? I mean, because maybe some guy really desperate, and I say, okay, if I win, I give you 80% of my winnings.
We accept that position, and we are of the opinion that in certain cases where contingency fees were unreasonable, they were not given under the context of CISG Article 74. However, if I refer this tribunal to page 58 of the record at paragraph 39, it stated that the contingency fee in our case here is reasonable in the ordinary circumstances, and in that particular situation, we don't think we fall within the category of being unreasonable here. But if I may then finally conclude on the second issue of the on the second issue of mitigation, we anticipate that the respondent may raise our silence to their clarification on the defective arbitration clause as an issue of the claimant not mitigating the situation here. But our position is this, that the clause in itself is valid, even if the clause is not valid. Commentators such as Mr. Gary Bond has stated that courts and tribunals, to a large extent, give effects to the defective arbitration clause. The rationale behind it is to prevent...
The point is not that, right? The point is that you could have said that. I mean, you could have at least replied and said, I disagree, the clause is valid and we will start arbitration. You didn't, you just kept quiet. Right? That's the point.
Mr. President, we did not just keep quiet. We were in the process of finding a replacement and substitutes due to the failure of performance by the respondent. But even if we did,
You couldn't just write that. You couldn't send them an email. You couldn't drop them a message.
yes, Mr. President, but
And didn't you first commence action in the Mediterranean court?
for the injunction, there is no inconsistency for us to seek the injunction with the arbitration agreement, because under Article 33(5) of the VIAC rules, it stated clearly that parties may revert to state litigation, state courts to seek for interim relief to preserve their rights at the present moment.
I think that our concern is this. I mean, there is some ambiguity, okay? I mean, at the end of the day, yes, it was upheld, but it's not clear, right? I mean, the clause is defective. The question is whether or not it's so defective as to make it totally unworkable. They were obviously under some impression that it might have been. Didn't it behoove you to correct their misapprehension if you disagree?
Mr. President, the letter that was presented by the respondent was not a simple clarification of whether or not the arbitration clause was defective. If I may turn your attention to page 33 of the the record. At paragraph 4, the third sentence from the top, and if I may quote, otherwise we would, second sentence from the top. If you consider the clause to be an arbitration clause in favor of the BIAC, we will be willing to agree on the BIAC standard clause with the addition of document disclosure being excluded. Otherwise, we will start court proceedings before the High Court in Capital City. There was, from the reading of the letter, there was simply no room for the claimant to take a position of saying that we insist on arbitration clause, because the only way that we can insist on this arbitration clause is to have the document disclosure being.
No, you can just say we are going to arbitration in accordance with our clause.
Yeah.
Right? I mean, why do you have to go and agree to all these additional things just to clarify the position that there's a binding arbitration clause and that the matter should properly go to arbitration?
I mean, to follow up on Brother Arbitrator's question, I mean, your dear friend in your firm, Mr. Horace Fast Track, the lawyer, right? He doesn't write letters to say, no, I disagree. This is the daily practice, isn't it? Saying, I disagree with you, you are totally wrong, I will commence it without any further notice to you. We will look to you for all costs incurred by any bill bringing to court because it is wrongful. So Horace Fast Track was sleeping on the job, and now you're asking us to give it to you.
Mr. President, this is not the first time in which the respondent tries to paint the claimant in a negative perspective. If I may refer you to page 35 of the record.
I think you should also address the question that was posed before. What do you remember what it was?
I'm sorry, can I clarify the question?
The one about the commencement of proceedings, and also the fact that you could,
I could just
you could just start arbitration without agreeing to all these things.
Mr. Arbitrator, we concede that we could have, in the perfect world, wrote despite our busy schedule to the client. Unfortunately, that's not the situation in our case. And we have to stress again that there is no duty on part of the claimant to respond, especially when there is only one international arbitration institution in Vindobona that could possibly be the institution to adjudicate the situation. What our position is that the claimants the respondents are finding excuses for us to change our requirements on document disclosure. And again,
But you just considered that you don't need to accede to those requests, right? Or
yes, Mr. Arbitrator. So our position is that this is simply a paper trail that's set up by the respondent to show that the claimant is not cooperative. And they have been doing it for several times, if I may, on page 35, where there are requests of a sole arbitrate, fast track proceedings in order to resolve the situation quickly, also came along with the requirement that we give up our request for document disclosure. So time and again, we don't think that this is the rightful way of a cooperative business partner should act, and this is why we urge this tribunal to grant the damages to the claimant. And if there are no further questions, we will conclude myself.
Okay, thank you. Right, here for the respondent of this. Go. Yeah, no problem. Please.
Thank
Yeah,
you.
yeah. Please go ahead. I ordered this. I got all about rubbish. One apple pie, one corn cup. Actually, you got one meal plus apple pie corn cup. That's just right.
Are you ordering as well?
Yeah, he's ordering.
Okay,
Actually,
I ate at last night. I don't like McNuggets.
yeah, that one.
How many pieces?
Six, yeah.
But their concern is still the West Judicata thing.
It's not even just the West Judicata thing, because the West Judicata thing is a very focused showstoppers of the thing. Their concern is am I going to be seen as interfering in the jurisdiction of the state? So you have to raise the West Anchor Orbiter, the one that the guy said that if thing had been considered before the state court and they ruled that this something that either side has caused was damages, you'd be okay with it.
You see, I thought that line,
Yeah.
but then the facts of the West Anchor is
Yeah, I know the facts are different. Yeah, and why they called you out on it because they know about it. So
the reason why they awarded the damages in West Anchor was because enforcement was
no, but
really
part of the reason why it was not willing to destroy you on it was because you were so damn weak on it. So you should have said confidently
okay.
that this is the principle. We say that it applies to the present case even though the facts are slightly relevant to the record. Focus will be whereas the poster that they might have a better argument for us than our clients, but I mean that's what I would have done.
Like, okay, I wouldn't call the idea that you just go back to the or and just see how it's done. But even if I go back, I will still going back to the graduate.
Yeah, no, because you weren't convincing on it. You just weren't giving a convincing answer. But okay, for moving forward, and I suspect the weakest part of the case will be article, but yeah, or whatever she decides to write. So take time.
These are all nuggets, right? I know I said almost impossible, but you all were saying impossible.
I never see. No, I told you.
Yesterday I went to watch one video. I said almost impossible.
Yes,
But you all would, the judge in their head, you would think it's impossible.
almost
Yes, that's the point, right?
The point where you ask you then he ask you what you arguing. Alamak, bro, you never
Because he read what?
No, we're not continuing. You reject all those Doesn't that mean that you're not even saying what people? No, they will agree.
Because he read what?
No, we can.
It's not here about half an hour. Last time, the last one, we had long one.
You're a legend, even seeing one students nowadays.
We only assume which for this set of proceedings. Guys,
Okay, shall
not
we?
recording.
Right. Here for the respondent.
Good evening, members of the tribunal. As earlier introduced, my name is Li Tian, and I am second counsel for the respondent, Vino Veritas. I will be speaking for 12 minutes, and I respectfully reserve 1 additional minute for Sir rebuttal. I will be addressing the issue of whether the claimant can claim the attorney's fees it incurred first in his application for an interim injunction in the Mediterranean High Court, and second, In its defense against the respondent's application for a declaration of non-liability as damages under Article 74, we say that attorney's fees cannot be claimed under Article 74, and even if they could, the claimant is precluded by its own conduct from claiming the attorney's fees it incurred.
Are you saying that there's no power to order these kind of damages, or are you saying that there's a power but it should not?
Mr. Arbitrator, we are saying that, Mr. President, we are saying that such a head of damage cannot be claimed under Article 74. And the claimant has hinged its claim on the principle of full compensation. But to that we say that the principle of full compensation is not absolute and must not impinge on the principle of equality between contracting parties. And the principle of equality between contracting parties would be violated if attorney's fees were awardable under Article 74.
Okay, you say that the principle of full compensation should not be, in the sense it should not violate this equality principle. Where do you get that from?
The principle of equality.
Where do you get this proposition that compensation cannot violate equality?
It is an implied principle in the CISG, Mr. Arbitrator, because the principle of full compensation in itself is not explicitly stated in any provision in the CISG. It is inferred from Article 74. Similarly, the principle of equality is also inferred from Articles 45 and 61.
Is this through your own ingenious reasoning, or is it from somebody who has written something about it?
This is the interpretation that has been taken by commentators writing on the matter.
Of like who? And what did you say?
Professors Ingeborg Schwenzer and Professor Peter Schletschmann. So they have actually written in their commentary on the CISG that attorney's fees cannot be claimed on the basis
No, I'm not going there. We got to start from first principles. Since you started with first principles, let's talk about first principles. I'm saying, who says that equality is an implied principle in CISG?
Mr. President, a commentator, Mr. Guida, has written an article analyzing the award of attorney's fees under Article 74, and in this article he has explained.
I think Mr. President's point is a broader one, it's a more general one on the principle of equality. Yeah. So maybe you want to address us on that first before you go to the attorney's fees.
Mr. President, just to clarify, your question is where I might find the principle of equality.
Yes,
from
look,
where I'm.
Yeah, because you're saying that you're trying to tell me that the full compensation cannot impinge on the principle of equality. Where is this principle of equality? Where does it say that we are supposed to call equality?
Mr. President, if we look at Articles 45 and 61 of the CISG, these two articles provide for both buyers and sellers. Both buyers and sellers are given equal rights in the event of breach. But this is not the case for attorney's fees, because the claim for damages is contingent on a breach of contract, and the successful claimant would be able to prove breach and therefore would be able to claim attorney's fees. But a respondent who successfully defends against the claim for breach of contract would not be able to claim for attorney's fees unless the claimant has also committed a breach of contract.
We don't have equality for equality's sake. The reason why they can claim for attorney's fees is because you messed up, right? You breached the contract and then you still went to do something else that made them incur more cost.
Indeed, Mr. President.
Yeah.
And in fact, the claimant has cited various German and Chinese cases for the proposition that if the claimant incurs costs to compel and ensure performance, it will be able to claim such costs under Article 74. But with respect, members of the tribunal, we say that those authorities do not stand for that proposition, and we may distinguish them in due course. Now, for the German cases that the claimant has cited, the tribunals explicitly...
Sorry, counsel, just stop with that. I'm trying to bring you back to this, but because you raised it, so I have to explore it fully. Okay, I'm just saying, why are you saying that equality is breached? If you can be the defendant, and if the claimant does something outside that causes you to lose something, you can claim it, and the counterclaim, and we will give it to you. But so in this particular situation, they are entitled to certain things because of your actions. Why is that not equal? I mean, or are you dropping the point of equality? I don't understand why equality is offended here. I mean,
Indeed, Mr. President, if the respondent had a counterclaim, it would be able to claim for the loss that it has suffered, including the attorney's fees that it incurred. But if a respondent does not have a counterclaim, and if it defends, if the claimant sues the respondent for breach of contract, and the respondent is successful in its defense, it has to incur loss because it has hired lawyers, it has hired attorneys, and it has incurred attorney's fees, but it will not be able to claim these attorney's fees.
but
under
Councillor,
Article
what I'm saying is
74.
that can we not envisage some circumstances where, for example, you are forced to defend somewhere else, and then we can give you the cost as well. I mean, that doesn't make it unequal, right? I mean, let's assume now they start something, and you are saying I had to go and defend you in 2 jurisdictions, so I'm going to claim it as damages under full compensation. Yeah, okay. I mean, that must follow from actually what they are saying. That whichever party is defendant or claimant, if you are forced into expense, that is damage. That's essentially what they are saying. If I'm forced to unnecessary expense, that's damage and I can claim it. I don't see why that the defendant is not entitled to that. The defendant is as entitled under their proposition. There's no offending of equality here. Not to what I can tell, for what I can tell.
Indeed, Mr. Arbitrator, in that scenario, there may not be an offending of the principle of equality. However, on the present facts, the Mediterranean High Court has already made a decision as to costs, and the claimant is essentially seeking to recharacterize this decision of the Mediterranean High Court, and it is seeking to claim the same sum as damages in the present proceedings, and we say that this cannot be allowed.
What was the reason for why they didn't give me cost?
If I may refer this tribunal to page 59 of the record, at paragraph 44.
59, yeah.
So we see here, that the claimant had asked for costs in both actions, but no order was granted because under the Mediterranean Code of Procedure, each party is to bear its own costs. And what the claimant, and as Mr. Arbitrator had previously pointed out, this issue has already been decided by the Mediterranean High Court, and what the claimant is essentially seeking to do is to appeal the decision of the Mediterranean High Court.
The Mediterranean High Court decided that under Mediterranean's procedural rules, applying Mediterranean's cost rules, the claimant's not entitled to costs. What they are claiming here is an entirely distinct thing, which is under Article 74 of the CISG, are they entitled to claim costs as damages? And I see that as a different question from that which was before the Mediterranean High Court.
In fact, Mr. Arbitrator, if we view costs and damages as different, the claimants, but in response to Mr. Arbitrator's question, the claims for costs in the present proceedings will not be claimed under Article 74. This will not be allowed. Instead, the cost of the present proceedings will be brought under Articles 37 and 44 of the VIAC rules, and not under Article 74 of the CISG.
But I believe the claimant argued that, and Mr. Wan, you can correct me if I'm wrong, that it was claimable under Article 74.
But indeed, Mr. Arbitrator, there is explicit authority to the contrary that is not allowed, such as the Zapata Hermanos case, which opposing counsel has raised, as well as the leading commentaries on the CISG by Professors Schwenzer and Schlettrum, as well as the CISG Advisory Council.
What exactly did you say you've raised these authorities? What exactly did the authorities say? That you can never claim costs incurred for interim relief, for example? Never? Is that what it says?
The authorities say that attorney's fees cannot be claimed under Article 74.
Attorney's fees for what?
Attorney's fees for attorney's fees in general, because different countries actually characterize attorney's fees and costs differently. So if Article 74 was such, if all claims for attorney's fees would be brought under Article 74, then the procedural rules and costs of many jurisdictions would be disrupted. And actually, as Justice Foster mentioned in the Zapata Hermanos case, this could not have been envisaged by the parties. So he mentioned that the United States could not have thought that by signing the CISG, they would have been abandoning the hallowed American rule that each party is to bear its own costs. And in fact, Mediterranean, like the United States, adopts the rule that each party is to bear
No, I
its
see what you're saying, but I disagree because parties have submitted to arbitration. Okay, arbitration has its own rules, and you submit to this tribunal, and this tribunal's way of dealing with things. But the tribunal cannot grant interim relief on its own. So you have to resort to certain courts. And of course, you submit to their jurisdiction, and the court orders that they make are binding. That's fair. But in essence, you are submitting to the jurisdiction of this tribunal for the substantive merits. So why can I not order that full compensation requires that you be also given damage from another proceeding? That's within the jurisdiction of the court, of the tribunal.
We submit as the respondents that this is, in Mr. Arbitrator's words, this is actually a sham claim, a disguised claim for the cost that it incurred in the Mediterranean High Court. And this tribunal is in no position to overrule the decision of a sovereign court.
Yeah, but I'm not overruling I do not intend to overrule anything. I mean, the point is this. I mean, perhaps I should phrase it differently. Do you accept that in international arbitration, full recovery is actually fairly normal? That means you not only get your damage, you also get full cost recovery. That it is fairly common in international arbitration for entire legal costs to be given. Not party to party, not even SNC, but full cost. Do you accept that?
Apologies, Mr. Arbitrator, I'm unable to assist on that point, but in
Okay, so I'm telling you as an arbitrator, that's what I do. We give it full cost recovery. So if that is true, why should the other party be any less? You know, the point is in my tribunals at least, where I am the chairman, we give full cost. But now they are out of pocket because you chose to do things that you were never entitled to do. You went to the court and sought a declaration when you should not have done that. And now they're out of pocket. Why should I not compensate them for that?
Apologies, Mr. Arbitrator, the claimant is not out of pocket because of our claims. It is out of pocket because it has bound its liquid resources out in the acquisition of a printing house. And in the case of the interim injunction, it was the claimant that chose to bring the injunction in the Mediterranean High Court instead of before an arbitral tribunal, which it could well have done.
I'm talking more about the declaration action. That was your choice, right?
To that, Mr. Arbitrator, we say that the claimant is precluded from claiming the attorney's fees incurred in its defense against that action.
Yeah.
And if this tribunal will turn with me to page 33 of the record. So page 33 of the record. This is a letter from the respondent sent to the claimant on the 14th of January 2015, 2 days after the Mediterranean High Court had granted the interim injunction. And in this letter, we informed the claimant of three things. First, that we considered the arbitration clause to be void for uncertainty, as the institution mentioned in it did not exist. Second, that we were willing to agree to arbitration. And third, that we would apply to the Mediterranean High Court for a declaration of non-liability if they did not reply our letter. The reason for that being that they had first initiated proceedings in the Mediterranean High Court, and we would be able to obtain both a declaration of non-liability as well as a lifting of the injunction by coming before the Mediterranean High Court. And the claimant chose to do nothing after receiving, seeing, and reading the letter, and after they had known our views in the clause, after knowing what it was that we were planning to do.
Counsel, I have two questions based on what your learned friend said. Firstly, are they under a duty to inform anything? Second question is, isn't this not really seeking their views, but rather trying to force them to accept your new terms of no document disclosure excluded, etc.?
And if I may add a third point, right? If you look at the arbitration agreement, I think it's quite clear that there's an arbitration agreement. So, I mean, why is there even a need to clarify with them?
Members of the tribunal, I will address your questions in turn. Starting with the third question, there is an arbitration agreement, but the institution mentioned in the agreement, the Vindabona International Arbitration Center, is non-existent. So if the respondent had, in reliance on the clause, brought claims before an arbitral tribunal, its claim could have been dismissed for lack of jurisdiction. And we would have been detrimented by that. And that was the reason why we sought for clarification from the claimant. And indeed, we were not threatening them by sending them the letter. We were not, the respondent's case is not that the claimant needed to immediately give a reply, a clarification, but they could have at least put us on notice and given us a view of their provisional a view on the matter. For instance, they could have just told us that, well, we think we will be getting legal advice, but before that, our view on this clause is that it is valid and that you as the respondent should not be going to litigation.
If you just look at the clause, you look at Article 20, it says, it shall be settled by arbitration in Vindabona by the International Arbitral Tribunals, VIAC. I mean, is there any other body named VIAC?
No, Mr. Arbitrator, there is no other body named VIAC. However, the claimant's own conduct was that just 2 days ago, just a few days ago, it had gone to the Mediterranean High Court itself and obtained an interim injunction in the Mediterranean High Court. And because of that, the respondent was led to believe that the clause was void for lack of certainty. And we were seeking clarification from the claimants before we proceeded with definite action on the matter. And because of that, the claimant is precluded from relying on the respondent's action further. The claimant is precluded from claiming the attorney's fees it incurred in its defense.
Fine, still, I don't think you've answered my question. Is there a duty on them to do anything? I mean, it's quite common for lawyers, I mean, though we like to fight a lot, to say, you just piss me off so much, you're just talking nonsense and trying to force me. I'm not sure to say anything. I mean, essentially, they just took one step further from the response. We will not litigate by correspondence. My views are stated as before. I mean, they just took you one step further and just not respond to you. But were they under obligation to respond to you?
To that, Mr. Arbitrator, the respondent's case is that the claimant was under a duty to cooperate in resolving uncertainties which resulted from the unclear wording of the arbitration clause. And this position is supported by academics such as Professor Thomas Newman. And so the claimant's refusal to reply and not even to put the respondent on notice or to state its provisional position as to the matter can be considered to be failing to cooperate and failing to fulfill this
Can I ask who drew up this clause? Is it them?
It was the claimants that drafted this clause, Mr. Friedenreich.
So I suppose even more so they should. So you not since they are the one who caused the problem.
Indeed. Mr. Arbitrator, if I may now move on to my arguments on the injunction proceedings. Now, the respondent's submission is that the claimant is precluded from claiming the attorney's fees incurred in the injunction proceedings because the claimant has argued that the injunction proceedings, the fees incurred in the injunction proceedings were foreseeable because the injunction was justified by necessity. But we see that there was no urgency to necessitate the bringing of the injunction proceedings before the Mediterranean High Court, and this is in fact recognized by the majority view under Mediterranean law. If I may direct this tribunal to page...
Sorry, I don't want to go into the merits of the injunction. I mean, that has been decided. As I said, I'm very concerned not to mess around with jurisdiction of courts. If there was no urgency, why would they grant it?
It was indeed granted under the minority respondent's case is that we did not cause.
Sorry, what do you mean by minority?
If this tribunal will
Yeah,
turn
sure.
to page 59 of the letter, at paragraph 48.
Mhm.
So we see here the fourth last line from the bottom. According to the majority view, the existing risk would not have met the threshold for granting interim relief, as the actual delivery of the bottles preventing fulfillment of the contract with the claimant was not imminent.
You appeal against that.
No, Mr. Arbitrator,
So I
we
mean,
did not.
I don't see why we should go behind, or there's no reason for us to doubt that the judge's reasons stand unless it's been overturned by a superior court.
Indeed, Mr. Arbitrator, we did not appeal that decision as Mr. Weinauer was suffering from a heart condition. However, it is our submission that we are not asking this court to appeal or to relook at the merits of the decision. We are merely saying that this court cannot award the attorney's fees because they were not caused by our actions. And in fact, the claimant's own conduct after obtaining the interim injunction demonstrates a lack of urgency. So the claimant obtained the injunction on the 12th of December
Sorry,
2014.
also, why does demonstrating a need for urgency, how does that relate to causation?
Mr. Arbitrator, that is because the respondent's position is that the claimant applied for the injunction not to protect.
Okay, but it's not about you lah. But so please be witty by all means. Okay, you can say certain things and laugh at the trial. You get them laughing, it's very honestly, rapport is very, very important. If you can get them laughing normally, you've done a very good job. But they're laughing with you, that's good. Okay, so just be careful. I mean, I think you all know yourself, each of you, which part you start seeing push. So that's probably where you